Okay, welcome everybody. Thanks for joining us. And this is going to be live streamed for those of you back home in your courts. Welcome. And for those of you who are here with us, I will tell you, for those of you who are home, it was difficult for us to get because the weather is so nice outside. And we're here in Portland, Oregon, in February, and it was difficult, but we got about 50 or so folks in the room with us, so we're happy to have you all here. So Peter Kiefer and I have been working on this project for about 5 years or so. It was an idea that Peter had right about the time of the NACM conference in July in Orlando, Florida, if you all remember that. And we have continued that, and that's the importance of this work, is that it's an ongoing and continuous survey. Some of you at home and some of you here may have taken part in the survey. We do send it out with some regularity. In fact, we have heard from 100+ of you in the most recent survey that we've taken. But for today, we are working on focusing on the discussion of the 2015 Conference of Chief Justices and Conference of State Court Administrators Resolution number 5. It's actually the 100% access resolution, and we focus a lot on public's changing expectations of the courts, and that's the foundation for this afternoon. So we will be going through that. That's the basis of the work we have for you today. We have some volunteers that will go over some scenarios, some snapshots that we have. So it's very interactive, and we hope that you have some fun along with learning some things and passing on some information for us as we do this continuing work. So thanks, Peter.
Okay. So once again, if you haven't done it already, if you want to take your smartphone out and type in the command line poll/EV/court futures, it should bring up the votes, the very first vote that we'll be taking. There's also sign-up sheets that are floating around here in case you haven't gotten the survey. Sign your name, your email, and we'll make sure that once we get back to Phoenix that we will send you the 2017 survey, which is out right now. So, what do you think's going on? Simple question. What do you think's going on? What do you think's going on? But you know, there's a spark of electricity in the air when you get asked that question. The New England Patriots just pulled off the most outstanding comeback victory in Rose Bowl history.
Rose Bowl?
Rose Bowl! What about USC? Okay.
USC.
Yeah, Super Bowl history. Blah, blah. But are they going to be in Minneapolis in 2018? What do you think? What do you think is going to happen?
Yes.
Mariah Carey ever going to be able to recover from her fantastic New Year's Eve lip sync disaster? What do you think is going to happen? Okay. State legislature is looking pretty flush this year for the first time in maybe almost a decade. You think we're finally going to get cost of living increases? I don't know. You think it's going to happen? Okay. Our case management vendor has been struggling to get the interface correct with the electronic payment system that we've got. Do you think they're ever going to get their act together finally? No. I don't know. Okay. But what do you think is going to happen? As you can see, we're constantly thinking about and trying to predict the future. And we're also trying to ask each other those questions. And because of that, we're going to be answering those questions today.
Usually when we conduct strategic planning, we're looking out a year, 2 years, sometimes 5 years. The work that we've been doing with the futures of the court is we were looking out 10 years. And when we do work on strategic planning, we're looking at a picture that what we might want to see. Well, today we're going to get a picture of the trends that are actually shaped and will shape over the next 10 years for us. So before we start, we want to warn you that, as I mentioned before, these sessions are highly interactive. We will ask you not only to engage in the poll everywhere, we will have some scenarios. We're going to ask your votes that way. And we encourage your comments. And through that, there's a growth in the work that we do that we can feed out to you. And as Peter mentioned, if you haven't taken part in the surveys, we'd ask you to sign up to do those things. we could have taken the volume of survey work that we've had over the 5 years, all the survey results, and you'll see some of that through this afternoon session. And we could have sat here and provided you that in a kind of a talking head, just fed you that information. And it's important and it's good information. But we thought in providing it this way, with us being able to kind of instill some discussion in this room, that, you know, is a much better way of presenting it to you.
Okay. So a little bit of background on our project. We called it the future of the courts. We do remember back in 2012 trying to pitch this idea to Michelle Oken, and she graciously said yes for us to start, and we are still thankful to her today. We have sent out a whole series of surveys over the last several years to a significant number of respondents. We now have over 1,000 folks who have responded to at least one of the 6 surveys that we have sent out over the years. We've sent them out to superior courts, to circuit courts, to courts of common plea, to justice courts, municipal courts, to federal courts, and also to AOCs. And we've sent them out to a significant number of respondents worldwide. So we've got a lot of our fellow court professionals from Canada, Australia, and New Zealand who have responded, plus a smattering of European countries. With that, oops, let me go back here for a second. What we do is we ask folks in the survey to give us their opinions of a series of scenarios. They're pretty short scenarios, and we ask to give us your assessment of the likelihood that a scenario is going to occur on a 1 to 5 range. As you can see, 1 being highly likely in 2026, the sun is going to come up tomorrow. 2, 5, which is highly improbable that we're going to be taken over by the zombie apocalypse. We then we average the assessments that come in. We categorize them into these large labels. As you can see, highly likely to likely, 50-50 chance, unlikely, highly improbable, based on the 1 to 5 scale and the averages that you get. And so what we'll be talking about are the results of a significant number of these surveys that we have sent out.
So to give you a hint on the scenarios that we're going to go over today, we will talk about will access to justice eclipse case flow management, bail and user fees. We've heard a lot about that at home and then certainly at some of our conferences, including this one. And then certainly if we have time, we're going to talk about the virtual courthouse. And so again, as we go through these and you have the opportunity to weigh in, it would be not necessarily what you would like, but what you believe based on what you know of your court and how things have gone, what you know nationally of courts, and that's how we want you to respond.
So, as I said, the first question that we're going to be looking at is, will in the next 10 years access to justice eclipse case flow management, known as justice delayed as justice denied, over the next 10 years? To set the context for this, let's take a look at the CCJ COSCA resolution, the 100% resolution, which has some pretty bold language in it. The judicial branch has the primary leadership responsibility to ensure access for those who face impediments that they cannot surmount on their own. That's primary leadership responsibility that we need to ensure that justice in proceedings involving basic human needs such as shelter, sustenance, safety, health, and child custody as one of the highest priorities for us who are denied access for those. And to ensure that no citizen is denied access to the justice system due to lack of resources or any other such barrier. This is pretty bold language from the Conference of State Court Administrators and the Conference of Chief Justices. So, I'm going to be honest with you. When I started in this business, the mantra was always case flow management. justice delayed is justice denied. We worked on continuance policies. We worked on electronic case management systems. We tried to meet those standards. We tried to meet those time standards. That was our reason for being as court administrators. But let me just give you two current trends and to have you think about, is this in fact a contentious issue now in 2017? First of all, a lot of you know that large companies are putting in arbitration components into their terms of service. You go online, you get a new app, you're clicking on that thing, maybe you read the little fine print, maybe you didn't, but usually somewhere in there is an arbitration clause, which means you have just forfeited your right to come to court. Another trend, trend two. 28 states now here in the country have an option for non-judicial foreclosure of people's homes. You do not even have to go to court to foreclose on an individual's home. It can be done entirely through the recorder's office. That's a significant number. Now, as a case flow manager, delay reduction expert, I'm going, yes, keep those cases out of the court. Save the court's precious resources for the real controversies that we're facing. As an access to justice advocate, I'm going, no! The courts are the primary forum for the equitable resolution of these disputes. It's us. It is not some sort of arbitration thing that a company puts on, and it's not a recorder's office in a bank that should be foreclosing on people's homes. You should be coming to the court. So with that, I ask you, do we have a potential contention between access to justice and case flow management?
All right, and with that, we'll have our first two volunteers. I use that word kind of in a so Michelle and Debbie will actually provide you with some snapshots, which then please listen closely because you'll have the opportunity to pick which one you believe will be our future.
It's Monday morning, January 5th, 2026. In the last 10 years, we've had a revolution in the courts. A 2015 public opinion survey showed that only 6 in 10 people thought the courts were fair and impartial. We took this as a challenge and, as the CCJ Cosca resolution urged, became the primary leaders for ensuring access to justice for the poor and the vulnerable. For years, we court administrators devoted ourselves to expediting case flow. Justice delayed is justice denied. Our goal has been to remove cases from court dockets as soon as possible. Now, courts lead the fight to expand access to courts. We're less concerned with getting cases out of the courts and more with having more people use the courts. We lobbied for more public defense and legal aid funding. We even took a budget hit ourselves as legislatures reduced court budgets to fund access to justice. But now free legal help is available for people being evicted from their apartments, homeowners going through foreclosure on their houses, caregivers who are not biological parents having their children taken away, and people forced to move to nursing homes because they aren't capable of taking care of themselves and are too poor to fight.
Okay, this is Snapshot B. Monday morning, January 5th, 2026. Over the last 10 years, courts promoted the idea of more access to justice as the CCJ Cosca resolution urged. We supported funding for the poor who could not afford to go to courts due to lack of money or proper clothes or ethnic bias, or even transportation to court. But courts can only do so much. Despite what the resolution says, this is truly not a problem for courts. State legislatures and county boards of supervisors need to step up. If they refuse to fund legal aid, well, that's on their heads, not ours. We have limited time and limited resources. Sure, we're concerned with access to justice, but we court administrators still focus on what we're experts at, case flow management. Don't forget that fundamentally, case flow management means getting cases out of the courts faster. Access to justice means getting more people into court. When forced to choose, we choose case flow.
Okay, thanks.
Oh,
So we're not leaving you to your memory on what Michelle read and then what Debbie read, but so we have it up here for you. So what, and certainly these aren't the views. Here's your your disclaimer. These aren't the views of the people that read these. So, snapshot A to remind you: courts take the lead, lobbying for 100% access to justice, better funding for public defense and legal aid, free legal help in civil, family, and probate. And then secondly, snapshot B, if you vote this way, courts support access but don't take the lead, advocate for more funding. It's really a problem for others, whether it's the legislature or local funding body.
okay, it is now time to take out your smartphone. Oops, people have already voted. I like that, okay. Vote for A if you think that Michelle's vision of the future is what's going to happen by 2026. Vote for B if you think that Debbie's vision of the future is what's going to happen. Have we all? Have you tried the command line and not go through Google?
Peter, it says it's full and it's no longer accepting.
Oh, wow, there you go.
geez.
You blew it up. All right, well,
Okay.
that's about half the group.
Oh. Boy.
That's
okay.
probably about half of those that are in here, but if it continued at this rate, it's still about 2 to 1.
Okay.
So anyone who picked either side of this want to offer any thoughts? Yes, you want to,
I
Mike?
don't think they need to be mutually exclusive.
Okay,
I think that you went to one extreme with one with scenario B and another extreme with scenario A. And I think the mid ground, which allows for both, is probably the ideal situation.
It's ideal. Do you think we're going to get to the mid-ground?
Well, I don't think we're going all the way to B. There will be a rousing cry. And if we go all the way to A, there will be a rousing cry. So out of the confusion, I think we'll find ourselves in the middle of the road.
Okay. Other thoughts?
So as a former public defender administrator, I think you're going to break on both, that there won't be enough resources for either case flow management or access to justice.
If we can't have both, where's the majority of the money going to go? Access to justice is going to eclipse case management. Other thoughts? Okay.
yeah.
We're going to go to the surveys.
Yeah, so, and thank you all for taking part and for that discussion. Let me now go to, there have been a number of surveys, as we've mentioned, and let me stop for a moment. Has anyone here taken one of the surveys over the last 5 years? Okay, thanks much. And as we've done these surveys, we don't have a scenario. We didn't have a scenario that in the survey that matched exactly, but these I think you'll find are fairly close. So what we did send out, and you might remember, states adopt standards to deal with self-represented parties. This scenario went out. It goes to the direction of the 100% access, and we sent it out in 2013, so a handful of years ago. Now we had 212 respondents to states adopt standards to deal with self-represented, and the end result, if you can track on the bottom there, our scale, ended up being an assessment of 2.1, which as we look at it is to the right, in the yellow, but still it's closer to the right-hand side, the likely and highly likely. Only limited jurisdiction respondents thought it had a 50-50 chance of occurring. And then two, we sent something else that was similar to all of this discussion. Differentiated case law management will get even more accurate. This was also sent out in 2013. 227 respondents sent back something on this one, and the scenario ended up being highly likely at 1.9 probability. All jurisdiction levels, general, limited, federal, and those that took part in this from the AOCs said that it was either likely or highly likely as a result of that question.
So, I'm kind of curious. I mean, first of all, yes, if you think about statewide standards for self-represented litigants, that goes more toward access to justice, that we need to have some of a independent measure by which we can judge how we're approaching self-represented litigants. But still, case flow management, differentiated case flow management, or now what we're calling the pathways, highly likely. So you can still see that we're quite dedicated and quite focused on case flow management. The one thing that Phil said was that the statewide standards, folks from limited jurisdiction courts only gave it a 50-50 chance. Who's here from a limited jurisdiction court? So, why do you think that the folks, your fellow court professionals, think that statewide standards has only a 50-50 chance on this important issue? Sarah?
Well, I think the self-represented litigants usually are at the bottom of the socioeconomic scale in many instances, and they end up being pushed to the side in the court because the lawyers don't like them because they're not using lawyers. The judges don't like them because they have to explain too much to them, and so I'm thinking that there is going to be a judicial move to influence the legislation that would prevent that.
How is that going to reconcile with the happy medium that you were talking about between
That was
case flow
point
management-
one. This is
Oh, I'm
point
sorry,
two.
okay.
But I do think that what's going to happen is that there, again, somewhere or another, those of us who deal with self-represented litigants know that they oftentimes get the short end of the stick. So I think the momentum is probably going to change things, but not as radically as you're hoping up there.
Uh-huh. So, who else was from a limited jurisdiction? Be brave. Come on, raise your hand. I thought of someone. Oh, go. Oh.
I guess I would just add that I don't necessarily think providing forms that are, I mean, it does provide better access, but I don't know that people automatically access judicial services because they know there's warm and friendly people at the, family counter or wherever. And I think access is not mutually exclusive to differentiated case flow, that you can create dockets that also provide more access to people. So it can be self-represented litigants, it could be people who are disparate, like poor, or it could be, there could be a lot of different ways to approach access using differentiated case management sometimes. So I don't know that those two things that you have up there are exclusive
really?
of each
Okay,
other.
because
So you can
When
create
I read
specialty dockets.
The Civil Justice Improvement Report, I don't mean to be disparaging, but it did seem to really sort of focus a lot on complex cases, the big important ones, and the middle ones. And then, oh yes, high volume is in there too, which,
Sure,
do you think
so-
that we're going to reconcile the dedication to increased access to the self-represented, who are the ones that go through the high volume calendars?
I think just because you're self-represented doesn't mean you have the same access to legal services that somebody who's not self-represented has. Is the outcome of your case going to be equitable the same way it would be if somebody who has money, who's not self-represented, goes through the court system? I don't know that that's true, right? So I think that it's great that we provide services for self-represented litigants, but I think mostly we do that out of convenience because we can't provide legal advice to them, and it's easier for us to process them through the court, and we want to help them. We see them struggle, right, at the counter, but do you get the same outcome as if that person actually has a legal advocate for them? I don't know that that's necessarily
I
true.
guess I'm confused. You're saying that self-represented probably do, what, about as well as somebody?
No,
who's
I'm
a-
saying they probably don't do
They
as
don't
well.
do as well.
Right, so it's not the same kind of access to the courts. It's not the same level of access to justice that other
Right.
individuals
And
have.
so then I go back to what the resolution said, is
Right.
that we take primary responsibility. How do we take primary responsibility for that?
I guess I'm not thinking about.
Somebody
just
else wanna
civil-
say-
Yeah, I'm not thinking about just civil cases. I
Okay,
mean, I think
all right.
think of it as a bigger issue, right? You've got family law, you've got civil, but you also have criminal cases, and you have a lot of different
Yeah.
kinds of people coming through your criminal
Okay.
courts. So if you think of it, bigger is we provide justice services to our communities, right? And we want everyone in our community, whether they're homeless or whether they're a business owner or whether it's small claims, whatever, we want them to have access to our legal services.
Okay,
I want to say one thing.
okay.
I hope that their solution is not to go with court-appointed lawyers, because they still end up being self-represented in many instances.
How
The
so?
lawyers who run in 5 minutes before the case, find the client, introduce themselves, get paid, but the client really doesn't get the representation that one was expected. So I hope that's not the solution.
Okay. Other comments? Okay, I think we'll
We're going to move on to
move
the.
on.
Well, and you can see what we tried to do here. Whether you had thought about it before you came into the room today, we tried to juxtapose these two issues, access to justice and case flow, whether they're converging and there's going to be this tension or not. I mean, we can sit around and talk about that for a lot longer than we have time today. We're going to go on to something a lot easier, which is bail reform. So our next snapshot deals with bail and user fees. Bail has long been regarded as a barrier preventing full access to justice. Will the cash bail system be eliminated nationally within the next 10 years? Likewise, user fees for a variety of justice systems functions have come under criticism.
Okay. We're going to move over to the Arizona Task Force for Fair Justice for All, because we're from Arizona, which said that the traditional bail money system has little to do with actual risk, and it's expecting money to effectively mitigate risk, especially risk to public safety, is historically unfounded. That what we use bail for isn't what we really get for bail. It also goes on to say that from a public policy perspective, cash bail flies in the face of good government, because basically it takes out of hands of government officials the most precious control over the most precious resource we have outside of our schools, and that is a jail bed. It's the most expensive resource we've got, and they don't even have control over that. Now, in terms of, we said it was bail and user fees, and so for user fees, we turn to Mr. John Oliver. Yeah. If any of you have seen his show called Last Week Tonight, this was back in 2015, but he discussed user fees on his show, and we've taken out a very short clip.
Access to a lawyer is supposed to be a constitutional right, and it is increasingly under threat. For instance, in 4 states, you can make so little that you qualify for food stamps, but still not be poor enough to get state-funded representation. And in at least 43 states, you can be billed for a public defender. Meaning, in these states, we have a system where conceivably, if you cannot afford an attorney, one will be provided for you, provided that you pay that attorney. Which is absurd. You can't tell people something's free and then charge them for it. This is the American judicial system, not Candy Crush. And for what this can look like on a human level, meet Larry Thompson. In 2010, he was arrested in Florida for driving with a revoked license, which was a felony charge because he'd had multiple driving violations before. Larry was sent to jail, where he applied for a public defender, which in Florida, incredibly, requires a $50 application fee. He couldn't afford to pay that or his bail, so he was stuck in jail for 59 days, at which point he gave up and pled no contest to get out and was released on time served. But in Florida, if you use a public defender and are found guilty, even by plea, you then owe attorney's fees and costs regardless of your ability to pay. So Larry now owed not just the $50 public defender application fee, but also an extra $100 fee for having used the public defender, and even another fee of $100 to pay the prosecution's costs, which is like a bully taking your lunch money and then charging you an additional lunch money reallocation fee. But they still weren't done. On top of those and other fees for the crime he pled no contest to, the court then added partial payment fees each month for the next several months, bringing Larry's tab to $675. And that all brings us to about a month ago, when Larry was actually arrested for contempt of court as a result of not paying those fees. An arrest, incidentally, for which they charged him a $210 administrative fee.
Well, Larry, you know, it certainly can be put into humorous fashion, but we probably have either know of cases like this or have heard of other cases similar to this. Let me call on our next two volunteers, Angie and Amy, to give us scenarios on bail and user fees.
Okay, scenario A. It's Monday, January 5th, 2026. It has long been known that bail is a barrier to access to justice. It keeps the poor in prison. It allows the rich to go free. Even judicial officers quietly admit that bail is set up at a certain dollar amount, usually around $700, and people stay in jail. Below that, and people get out. The courts took the lead, lobbying to eliminate cash bail and user fees to government services, particularly the courts. Along with other organizations, we in the courts advocated for tools other than cash bail to ensure defendants appear in court and keep the community safe. We also look for funding sources other than user fees to supplement our budgets.
Okay, scenario B. It's Monday, January 5th, 2026, and the courts took the last 10 years urging the elimination of bail and user fees. Today, more defendants are released on their own recognizance and wear electronic ankle bracelets. However, bail is still a basic part of the justice system, and user fees still pay for a lot of court, police, and prosecution services. The fact is that the public never saw bail as a rich versus poor problem. The public saw it more of a dangerous criminal versus safe community issue. Guess which side wins that argument? Plus, there are active interests such as bail bond companies and prosecutor offices that have an active interest in keeping bail as a tool. User fees have also become so ingrained in funding the justice system that eliminating them is out of the question. Courts, police, and prosecutors all receive too much additional funding from fees such as establishing time payments, probation officer visits, driving school, and being represented by a public defender.
Okay, thank you both.
Thanks.
I will recap or summarize the snapshots that we have here, although probably 11 of you have already voted. Not that I know that, but the cash bail system has been largely eliminated under snapshot A. Tools other than money are used to ensure defendants return to court. Pretrial detention is no longer used as punishment for defendants. So that would be if your choice is snapshot A. Snapshot B, some progress has been made, but cash bail largely remains. The public never really understands the problem of cash bail, and opponents lobby to maintain the status quo. How strong is...
Could you explain what you mean by tools?
Do you,
That's an excellent question, because that came up this morning, and there was never any definition of what tools were, but there is a reliance on new and innovative tools which will reveal themselves in the years to come. So, well, vote fast in case the thing...
it's full. Seems to cap at 18. Oh, it's capping at 25? Okay, we're at 25.
How did that happen?
We need to pay more.
Yes, I'm gonna have to go on the premium account to get the full.
Yeah, the free app gives us this. The last 20 we're going to go with A, so it's thrown us all off. All right, we're not quite as optimistic as our progress forward on this issue, right?
Should we go through the survey?
Yeah.
All right. Well, we can see it's mostly cash bail is still going to be around and user fees are still going to be around.
All right. So, to look at the surveys that have gone out that are close or at least relative to this, money bail is abolished. That was the statement or question sent out to survey takers. Survey said maybe. We're running the scenario this year. At the time that we went to print, we had 92 respondents. We have now
150 respondents, but they're not all logged in.
So we have actually had, but at the time of this, we had 92, and our result there was 2.9. So on the scale, it was like a coin flip. Then the number of user fees dramatically increases. Went out in 2015, we had 475 participants, and they said it was likely at 2.2. And then the next, another question that went out actually went out in 2013 with 181 respondents. It was court revenue from user fee increases. Now this came back as highly likely. So court revenue from user fees increases. So 3+ years ago, it came back as highly likely. And then courts accused of creating debtors' prisons. We ran this in 2015. 452 respondents, it came back as unlikely. Okay.
All right. You can almost see what the question I'm going to be asking you is here. Okay, the CCJ, COSCA resolution strongly encouraged an elimination of debtors' prisons and a reduction in user fees and a severe reduction in the use of cash bail. And yet most of you in this room, including your fellow court professionals out there in the world, said, ain't gonna happen. Why? Why is that? Okay, Dexter.
One of the things with the cash bail is everybody will comply with getting rid of a bail schedule. But the thing that will take years to come is getting rid of judicial implicit bias. That schedule is in their brain. Whether you get rid of it on paper means nothing. What comes out their mouth will be bail set at, while there's no schedule, it's already in their brain. So you can get rid of it on paper. You can say the bail schedule is gone. But they're going to place something because these elected judges will not want to be on Channel 12, Channel 5 for that one case that gets out and something bad happens, because then they won't get reelected.
See, he was off camera, but everybody will know where it came from.
Who else wants to chime in on this? Because this is a pretty significant issue that we seem to be at odds with CCJ COSCA.
I don't know if it's a matter of being at odds with them, but I think there's just a different level of difficulty with making the change. I don't know about all states, but I know in our state we have a constitutional provision that requires bail. You can't just abolish it without opening up the Constitution and having a constitutional amendment. So that's not an easy thing to do, and politically there's a lot of folks that don't want to go into that, because once you open up the Constitution, then you can get into all kinds of other issues as well, not just the one that you're aiming at.
Okay.
Well, I agree with Kevin, and I would add that the difficulty in convincing legislators that the turnip cannot be bled anymore with regards to user fees is another huge issue, because they want to appear to be tough on crime, and they see part of that as being imposing fees for various services rendered. So I could see the court taking a lead on that, but the change happening in 10 years then goes back down the scale towards unlikely, I think. It takes time.
Okay. Jeff.
Well, I don't want to sound like a cynic, but having worked with legislators for many years, I can tell you that legislators are addicted to money because money funds services, and the courts don't have constituencies that can convince legislators to give up monies. And if you doubt that proposition, all you have to do is look at almost any state's fines and fees associated with traffic violations and look at all the different streams of monies that those traffic tickets fund. My favorite quote from a legislator was, "I know that a traffic ticket doesn't have anything to do with preventing car theft, but that's the only way I can fund my car theft program, so I don't care." And that's the future, the present, and the past.
Okay, Sarah?
I just wonder if you've given any consideration to this idea of no longer having bail and case flow management, because most of us know that when grandma pays the bond or posts the bail, they show up in court because it's grandma's money. Otherwise, they don't come. So if we're looking at access to justice and expediting case management, case flow, it's not going to happen if you eliminate that, because we'll have all of these old cases for these people who didn't come because they got a free ride.
Okay, you're rethinking your whole position originally in the presentation about a balance, and we're going over to case flow management.
You have me thinking.
It's converts we're after.
Yeah. I do have one last question, yes, of Kevin and Liz. Okay, I get the reality about bail. How do you reconcile this with the admonition of CCJ Casca that the courts take, the judicial branch takes primary leadership responsibility? We're supposed to be out there right at the forefront. And are we going to be out in the forefront?
Follow the money.
Okay.
We may be at the forefront. We may be banging the drum. We may be saying that there's a better way to do business. But you still have to understand the political reality, as was pointed out, that we're in a situation where there are different branches of government that have different focus points. So we can certainly be out there in front and try to make a change and try to make the case for it, but moving the needle forward is going to be a little more challenging.
Okay.
What Kevin said.
All right.
For those of us who attended the plenary here, and it was one of our judges that was speaking to the drop in revenue, I mean, that was probably a little chilling for a lot of us to hear. Not that we have to solve that problem necessarily, but it's a problem that we have to go through or around or something with our other agencies and those that we deal with, because, and I will guess that his what he was quoting us was accurate. It probably is, but when you say that there's a third or a half drop in revenue for certain things, on one side it's good because it's probably, you know, he did relate some of where that money was coming from, the grass that's growing too high, so that somebody's having to pay some ordinance fee or something like that. But how do local governments deal with such a loss of revenue? I mean, we just saw that not too long ago when we were all forced to through 2008 and 2011 with the recession. We lost, I think, a lot of staffing that way, but this would come down in the same type of result for us, possibly. Okay, moving on.
Moving on.
All right. I'm sure there's an issue that's a lot easier than the first two, but news articles are reporting that our newest generation, Generation Z, I do not know where we go from here because we've run out of alphabet. These are those young people, 23 years old, born in 1994. I actually have one of these living at the house. And they're demanding everything. This says are demanding everything electronic. I think I would just put a period demanding everything.
What's the matter with kids today?
But our third set of snapshots ask how the courts will respond to those new users who are coming in. Will we move to 100% access finally to evolve to a virtual courthouse, for example? So we have two last volunteers to read snapshots.
Yeah, I know.
Apparently, we have one volunteer for now. Okay, this is scenario
Who's gonna make
A.
an entrance?
Yeah, it's going to make an interest. This is scenario A. It's Monday, January 5th, 2026, and the court's advocacy for 100% access to justice has made truly innovative use of technology. People can now go online and walk through computer apps to complete any court form necessary through smart forms, electronically file the documents, pay the filing fee, and do it all from their home or office. Landlord-tenant forms, child custody, conservatorship and guardianships, orders of protection, divorce, modifying family court decrees, and fighting default judgments are all available from the court's website. Smart form applications go well beyond simply fillable forms to asking a series of questions just like TurboTax, used for completing one's income tax. As a result, fewer people need an attorney to help. They really can do it themselves. Most court hearings are by audio-video conferencing, and many are conducted through mediation apps. Few people now actually come to the courthouse, and the poor have much easier access to justice.
I don't know what world you're living in, Liz. Because where I'm at, it's Monday, January 5th, 2026. And yes, parties can do more online. Most courts use fillable court forms, meaning a person can fill out the form online, print it out, and sign it, and then walk it over to the clerk's counter and file it, pay the filing fee. Getting a fee waiver still requires waiting around for the judge to appear in order for him or her to approve the petition. Some routine hearings are conducted over a conference phone, but most judges still want the parties physically in the courtroom. People can see more filed documents online, but there are lingering concerns over potential abuse and errors, like mistakenly posting documents containing sensitive information. And that keeps full public access online very limited. To see most court documents in person, they have to come to the courthouse, request the electronic court documents on a computer located in a specific file viewing room.
Okay, thank you both. All right, to go over the summary of Snapshot A, smart forms and applications are used, more litigants are self-represented, computer access to all public documents, reliance on audio-video conferences for hearings, and then Snapshot B, fillable forms on the court's website, conference calls for routine hearings only, and restricted access to public documents.
Okay, time to vote. The third and last vote. Vote early. Probably can't vote often because we got a 25 vote limit.
21, 2.
So we are going to see a virtual courthouse. I like that.
Yay! They were all basically 18 to 7 and 16 to
I wonder
9.
who that 8 and 9 folks over there.
At least we got some sort of a split. Anybody want to comment as to which side they may have chosen?
Oh, there you go.
Well, in Oregon, in my court, I think we're much closer to scenario A already than we are to scenario B, and I see that changing and progressing every day. You know, the ability to file a divorce petition, to fill it out online and file it electronically is here. Yes? I'm looking at, yes. It's here.
You have to look over to your tech guy to figure this out.
Actually statewide.
Oh, okay, yeah.
Right.
All right.
So in large respects, I think scenario A exists.
Okay. It sort of reminds. When I worked here,
There was an although.
When I worked here, the state court administrator appeared before the legislator, was it the Ways and Means? And he would be up there, and the entire support staff were in the front row of whatever the budget hearings. And he'd say, "Okay, I believe this is the way it is, unless the people behind me are shaking their heads now." Oh, jeez. Anyway.
Was there?
Does this intersect with access to justice? This expectation that it will be virtual. How does that intersect with access to justice?
You don't think that the virtual courthouse doesn't?
Have the technology that they need to do this?
Okay. Go ahead.
So I was going to say in Los Angeles, our court is moving towards more towards the virtual as well. And we find that a lot of our customers do have smartphones. We're developing apps for them to use. We have public terminals. We have kiosks. They can now go online and pay traffic tickets. We have our own virtual woman named Gina who will talk to you
Just
on the
like
website.
Siri?
Yeah, similar. So I would say in 10 years, I can definitely see, and at least in Los Angeles, and I know Orange County, which we saw a couple of things on Orange County, and they're also in that same realm with the remote interpreting. So
I've got to say it. I mean, shouldn't the name be Cortana? I mean, really.
No, I was just gonna say.
Oh,
the same
okay.
thing. She said we have kiosks.
So,
They don't.
okay.
Is it cheap?
Sure.
That's the question. Does it save money, right?
Hmm? What do you think?
I have no idea, but the people who are doing it, is it cheaper than having
Oh.
less clerks?
Okay, so there goes your.
But you still need clerks to deal with the people who have trouble filing it online, or they push the button, but they don't understand that they actually filed it, so they come in and they want the reviewer to look at it, and the reviewer pulls the case number up, and they're like, you filed it. Well, what they filed isn't what they want, so now they have to file and amend it. So you can talk all you want about virtual courthouse, but you still need a human being.
Well, and maybe,
Human beings still want human beings.
and maybe that goes to Sarah's question from a minute ago. Are we leaving anyone behind if we move forward with certain technologies and too fast for some?
Well, I think for me too, it depends on what type of case type are we dealing with. I mean, I don't want my custody case settled over a computer. I want somebody to see that I am interacting with the court and it's not over some, I don't know. I just don't feel like we're putting a story in front of a judge to actually make a decision on if we're doing it electronically. I mean, I think that you need to have some of that face-to-face in our court system. You can't do it electronically.
Let me ask you a question, though, about it. Both of you, you can hold on to the thing, is that,
I don't need it.
okay.
She's got it now.
I don't need that.
I mean, I don't know how many of you use TurboTax, but I'm assuming that a number of you probably do. Now, we remember in the day that either you did it at your kitchen table, probably at 2 o'clock in the morning, breaking a whole bunch of number 2 pencils, or you went to see a tax advisor, H&R Hup to Hup, or somebody else, and they helped you. But over the years, that app has become increasingly sophisticated. What holds us back from a system that would be able to accommodate those people? Do you think it ever is going to happen? Because it apparently has happened, at least to some extent, with TurboTax and other sophisticated apps. We're doing a lot more online now than we ever did before. Can we ever get there with the court? I mean, is there what's holding us back from becoming like that?
Well, I think just like I said before, you're talking about financial for me. And yes, that's huge to some people. But if you've got that right next to my 17-year-old daughter and there's a decision that needs to be based on her, I would never rely on something that I can fill out on the internet. I'm going to make sure that she is in the best interest of all eyes around her. So I think it's different in that aspect for me.
Okay.
I think that virtual courthouse, I think we're moving towards that and we're taking a good step there. But I don't know that you'll ever convince me that everybody is going to want to be a part of virtual courthouse. So when people start talking about virtual courthouse, and I heard the comment, well then what do we need clerks for? You're still going to need clerks because you're still going to have a faction of people who want to be heard by people, not over a video. They want to actually, because video distorts, just like email. You can't read tone in email, or you read tone that's not there in email. People are going to want to be in front of someone who's making a huge decision about them.
Okay.
That's my point.
Now, as a defender, I don't want judges being able to convict people unless they're seeing face to face.
Well, actually, there are people that still need to see a facilitator or talk to somebody. And for us, this is actually a tool that allows that person to have more time with the facilitator, because people that are able to just do the forms online and don't need that help then aren't taking up the time of the facilitator. So they have more time to spend maybe with people that have a learning disability when it comes to reading or limited English proficiency, need an interpreter there with them. So we're able to give those people more time, and I think that does increase access.
Okay, I think there was, pass it back there.
I'm from Hennepin County, and we moved to pretty much all electronic filing. And in that process, attorneys all had to get on the bus. There's no more submitting it on paper. But for litigants, pro se litigants particularly, they can still file on paper. So it opens another door, but doesn't close the original path they could use. And we also haven't lost any staff in that process. The job changed, but no one's losing a job because of it. Like, everyone's still working, and it's improved everything significantly. A lot of times have been shortened dramatically. It used to be a week, and now it's an hour to process a lot of things. But jobs haven't gone away, and we haven't shut anyone out.
I wonder what the survey said.
Okay, survey results on questions that went out that are at least close to this issue. Courts will use smart form apps. That's a scenario ran in our 2014 survey. 501 respondents assess it as highly likely at 1.7. Next, most hearings were conducted remotely, ran in 2012. 186 respondents said it had a 50-50 chance. Federal respondents thought it was unlikely, and they rated it at 3 on our scale. And then courthouses will go virtual. We ran this scenario in 2013, again with 181 respondents, and they said it was unlikely. Any
So I think a
comments
lot of
about-
folks agree with you on that. So,
Any other comments? Yes. I knew you were itching to say something.
Yeah, what does this do to public trust and confidence?
Ah.
I mean, we're talking about public access, we're talking about access to
Mhm.
justice, but what does it do to trust and confidence? We're seeing a greater proliferation of community justice centers, and that is looking at the holistically more at the person. How can we do that online?
that's a really interesting question, because again, a lot of these public polling surveys that are talking about millennials and are talking about Generation Z folks who are just coming in to the court organization, maybe you got a couple, at least, and I'm not saying this is the case, but many of the survey results saying they have the exact opposite. How can you keep asking for trust and confidence to a tired old courthouse building down in a pretty bad part of town that I have to drive to get any of my business done on paper? So I would turn it back to you. Are we facing a generational change that's coming up? Go ahead.
I don't know if it's a generational issue or a culture issue. And I think culture plays a lot more important of a role than what we give it credit to. I know in some areas, I'm in Louisiana, obviously, we're going to have culture that does not change. It's not going to. We have to grow with it, or we have to submit to it. And I think in doing a lot of things online it's more convenient at times, but I think in some people's eyes, it loses the validity of the system. You know, if you want to be just another number, you don't want them to feel like they're just another electronic filing.
Yeah, okay, all right. Probably got time for one more. We want to get you guys out on time.
I'm going to speak for my millennial people.
Speaking for all millennials.
Speaking for all millennials. If you're telling me I've got a traffic ticket that I disagree with, I have to drive downtown, wait 45 minutes in a line to talk to a hearing officer, pay $20 for parking, or I can just go online. I want to go online. I feel like that's valuing my time. It's valuing my argument. Whereas if they're making me jump over hurdles, jump through hoops, I feel like it's kind of degrading sometimes. And like the experience is, to me, not the best. Other people feel differently, and that's why, we have virtual hearings for traffic tickets now, and some people love it, some people hate it. They think it'd be a ridiculous idea. They don't want to do that, and that's why we kind of keep both options open. I think my generation is like, why can't I just pay this online? Why can't I do everything online? Why do I ever have to talk to a human? That's my preference. You know.
Face of age.
So I think it is a huge generational difference.
So, okay.
Uh-oh.
Okay.
You can have the last word.
You have the last word.
Make it good.
My generation feels the same way about those sort of things that we, or at least I, might consider incidental. There may be other people who don't consider it incidental, who want to come and talk about other options as opposed to payment, because maybe they can't make that payment. So I think it is more of a, it depends on, you know, how important is that particular case type to me in terms of, do I need that interaction to make it feel like I've had my day in court versus paying a parking ticket. Yes, oh my gosh, let me pay those online, please.
So, okay.
We have some traffic.
Oh, we're getting a battle here. Thanks for both representing. Thank you all for your comments.
Phil, something you might need to ask in your next survey, though, is whether equal protection means equal for everyone.
Sure.
All right.
Or whether equal protection is going to need to focus on cultural differences or generational differences.
Okay, Kevin, next week I'm emailing you. We're gonna nail down this scenario. We already have 3 scenarios of the 2018 survey that we're already building, so thank you. Do you have?
Yeah, no, I just wanted to thank everybody for their comments. We hope that, you know, in this last 60 minutes that we've had with you, we've been able to explore maybe some of the future as we look out. Hopefully it's been beneficial to you. It's been beneficial to us in hearing from you. We take away from this as much as we hope that we provide to you. So thank you again.
A side issue is that we had a lot of fun doing this. We hope you did too. Thank you. Always be looking into the future. If you want to get ahead, look ahead. You can look back.